Now come to order. Let me just say something in regards to those of you who have been waiting since 10 a.m. this morning. I sincerely apologize, but as you know, the duties of the House are varied, and we did have to postpone this meeting and with a series of votes and other matters. So again, please accept my sincere apology for the delay. We are very cognizant of your time, and we value your time. So please accept our humble apology. And we will now proceed with this hearing. This hearing today is a hearing of the Subcommittee on Commerce, Trade, and Consumer Protection. And the subject matter is NHTSA, the road ahead. And the chair recognizes himself for 5 minutes for the purposes of an opening statement. The Subcommittee on Commerce, Trade, and Consumer Protection is again welcomes all the participants here at this meeting. Our main purpose for coming together today is to assess NHTSA's functionality and its effectiveness. Last month, I promised America's motorists, passengers, and pedestrians that as this subcommittee takes up its jurisdictional responsibility to reauthorize NHTSA, we will help NHTSA regain the public confidence. This is our first occasion to welcome NHTSA's newest administrator, Mr. David Strickland, to this hearing and to this subcommittee and to this committee. Although Administrator Strickland's first several months at NHTSA's helm have been rocky and filled with difficult challenges, I know him to be a highly intelligent, thoughtful, capable, and caring professional. I expect that he will shoot straight with us as we begin crafting reauthorization legislation that the members of this subcommittee can quickly support and move through this subcommittee and through the full committee and take it to the floor of the House. I look forward to listening to both witness panels and hearing their views on what NHTSA is currently doing through its crash data analysis, its research, and its rulemaking to promote vehicular safety. Although I am typically not very stringent about enforcing time restrictions on member statements and questioning, this is a different day. We are starting late, and because of the timeliness, I will not hesitate to drop the gavel today to keep us on point and, I might say, on the right path as much as possible. The right roadway would be more appropriate. We have a lot of ground to cover, and we expect a number of members to participate. And I will ask my colleagues to operate with a full understanding and to be as cooperative as possible as it relates to the time consideration. And before I yield my time, I would like to say a few words about the scope of today's hearing. And let me be clear. This is not a hearing about Toyota's recall or its practices. Please try to restrain yourself from veering too far away from our purpose of examining NHTSA and NHTSA's configuration, NHTSA's organization, and NHTSA's performance in the areas of defects investigation, safety standards, and enforcement. Again, I want to thank all of our witnesses who have taken time out of your very important schedules in order to advise this subcommittee. Again, I want to say we're very more than thankful to you for your patience. Let us work collaboratively and constructively to ensure that NHTSA has on hand the necessary resources and capacity to fulfill its stated mission of saving lives, preventing injuries, and reducing economic costs due to road traffic crashes through education, research, safety standards, and enforcement activity. You're all great Americans, and you'll become even greater Americans if you help us improve NHTSA. Thank you again. I yield back the balance of my time. And now I recognize the ranking member for 5 minutes, my friend from Kentucky, Mr. Whitfield.
Well, thank you, Mr. Chairman. I also want to thank you all for your patience, and we welcome the witnesses on both panels. I would like to start out, first of all, this afternoon by simply congratulating the National Highway Traffic Safety Administration. I noticed that today vehicles are safer than ever. In 2009, there were 33,963 highway fatalities, which is too many, but the fewest since 1954. The rate of fatalities in 2009 was 1.16 deaths per 100 million vehicle miles. And when this record was first recorded back in 1979, there were 3.34 fatalities per 100 million vehicle miles. I think that should make the public feel more comfortable, even though one death is one death too many. As a result of all the focus on Toyota, some commentators have opined that the system is broken and needs to be fixed. Those opinions are wide-ranging and point to many different issues, ranging from NHTSA's authority to the way in which it has utilized its authority. Mr. Sean Kane, who's president of the Safety Research and Strategies Company, which does a lot of consulting work for plaintiff trial lawyers, testified during the Oversight and Investigations Subcommittee hearing last month when he was asked the question, does NHTSA need more tools, more authority? He simply said that I think a number of errors were made in the process of these investigations, not so much that the tools were not available as much as the tools were not employed. So I think it's important that we consider all of those things as we move forward. As far as unintended acceleration, this is a problem that has cut across 3 decades and multiple administrations without successful resolution. Similar to NHTSA's finding in the late 1980s and early 1990s, when it commissioned an independent examination of unintended acceleration, or the more recent review conducted between 1999 and 2000, the current investigation has not answered all questions and may never do so to everyone's satisfaction. Regarding NHTSA's action, it is also not clear what more they could have done than what they've already done, and whether the outcome would be any different. Administrator Strickland testified last week that there simply wasn't a strong enough case to force the issue of a mandatory recall, even if that had been NHTSA's decision. And if a problem cannot be clearly identified, a proposed fix most likely will not have a meaningful benefit. I might also say that to date, the Office of Inspector General within the Department of Transportation announced the initiation of an audit of NHTSA's Office of Defects Investigation to include an examination of its handling of Toyota, as well as the broader issue of the process that ODI employs to examine and investigate safety defects. The Office of Inspector General's objectives are similar to those of this hearing, and that is simply to determine whether NHTSA has the tools and information available to investigate safety defects and identify possible improvements to its current procedures. And I think that's what this hearing is all about as we move forward with NHTSA. And I would yield back the balance of my time.
The chair recognizes the vice chair of the subcommittee, Ms. Schakowsky of Illinois, for 5 minutes for the purposes of opening statements.
Thank you, Mr. Chairman. I'm so happy that we're having this hearing today. Without a doubt, the National Highway Traffic Safety Administration's profile has risen dramatically as a result of its role in responding to the dangerous problems with Toyota vehicles, probably a little higher profile than perhaps you had wanted or anticipated. This hearing will give us the opportunity to explore whether NHTSA has the resources, expertise, and authority necessary to sufficiently investigate reports of safety problems and enforce existing safety rules. I want to welcome Mr. Strickland to and congratulate him on his new position and welcome him to this committee. I know that you really are an advocate for consumers, and it was really a pleasure to be able to work with you earlier on the Consumer Product Safety Improvement Act when we worked together and you were in the Senate. So I know of your commitment to consumers and consumer safety. My guess is, though, that right now we will find some gaps that need to be filled, and I look forward to working with Chairman Rush and the subcommittee and with NHTSA in crafting legislation to address those gaps. Mr. Strickland, in addition to discussing issues surrounding NHTSA's oversight and enforcement activities, I am looking forward to begin a dialogue with you about children's safety in and around cars and other proactive safety measures. I appreciate that we had a moment before this 10 o'clock hearing to discuss this a bit. In past years, Congress has enacted legislation requiring NHTSA to issue specific safety regulations. Dear to my heart has been the Cameron Gulbranson Kids Transportation Safety Act, signed into law in 2008, requiring rulemaking on a rear visibility standard and a power window standard. And I know that you're working on both of these issues as we speak, and it's my hope that both standards will be very strong in order to protect children. I have to tell you that I think the hardest thing that I have done in this Congress in my 12th year now is having parents come with pictures of their children who are no longer with us, sometimes because they themselves inadvertently, and I think we know in very large part due to design problems, actually were responsible for those children's death. It's just the most unbearable thing to think about, that these were preventable. And yet these parents have turned this tragedy into a crusade to make automobiles safer, not just in traffic, but not in traffic. So I am looking forward to working with you to create standards that actually do prevent those accidents from happening. My concern is that in the past that Congress was forced to take action because NHTSA was not initiating badly needed rulemaking on its own. And so I look forward to working with you to make sure that NHTSA has all the tools it needs and that it uses its tools to protect consumers. I look forward to that very much. Thank you, Mr. Chairman. I yield back.
The chair now recognizes the gentleman from Iowa, Mr. Braley, for 5 minutes.
Thank you, Mr. Chairman, and I want to applaud you and the ranking member for holding this important hearing. It's really an honor to have you here today, Mr. Strickland. We haven't met before, and you have an important responsibility that is too often kept on the back pages of most newspapers and magazines. And it's only when something dramatic like these Toyota recall hearings comes up that the public starts to understand the critical role that your agency plays. You look to me like you're a young man, so I don't know if you know where you were on December 2nd, 1994, but I know where I was. I was not sitting in that chair, even though I was supposed to be sitting in that chair, because I was supposed to be testifying that day in a recall hearing on side saddle fuel tank explosions involving CK General Motors pickup trucks. And I did not get the opportunity to testify because a settlement was reached that day between your agency and the Secretary of Transportation and General Motors, whereby $51 million was paid for supposed consumer safety programs so that the recall hearing would not go forward, where people like me would have an opportunity to talk about the impact on human lives of defects that do not get solved. And I was going to testify that day about a client of mine, a young woman in Iowa, who had the right side of her face burned off when the pickup truck she was riding in was involved in a collision, and the pickup rolled over on its side, and because of the placement of those fuel tanks outside the frame rails, the flames went up the side of that pickup truck and engulfed her face in flames. And her husband, who was driving the pickup truck, pulled her young son, who was seated between them, through the broken windshield and got him to safety. And when he went back to try to rescue his wife, he reached in to grab her and pulled out big chunks of her hair that had burned off in the fire. And he went back to his son and told him, "Mommy is in heaven now." But miraculously, this brave young woman survived and went through months and years of grueling, painful skin grafts, hair transplants, and incredible disfigurement because of that defect. And when we gather for these hearings, we spend a lot of time talking in very arcane, technical language about sudden, unanticipated acceleration and electronic control safety devices, but we rarely talk about the human impact of the failure to act. And so when you think about the important responsibilities your agency has, it's important not just to think about where we are today and where you're going to take that agency going forward. It's important to look backwards at the legacy of this agency and why there are some people who feel it has not fulfilled its responsibility to keep the American public safe. So I look forward to the opportunity to have a meaningful, long-term conversation with you about the important responsibilities you have, and I look forward to hearing your testimony today as we work together to get to the bottom of this unexplained problem. And I yield back.
The chair now recognizes the chairman emeritus of the full committee, the dean of the Congress, my friend from the great state of Michigan, Mr. Dingell, for 5 minutes.
Mr. Chairman, I thank you for your kindness and courtesy. I commend you for this hearing, which is very important, and I also commend you for your fine leadership of this subcommittee, with which you have done a splendid job. I want to observe that NHTSA's response to the safety defects implicated in these recalls has been sluggish. Likewise, NHTSA's decisions to terminate several internal analysis related to the defective Toyota vehicles since 2003 due to a purported lack of resources leave one with the impression that the agency lacks the appropriate level of personnel and appropriations with which to fill its mandate. We want to find out if that's the case today, because if that be so, then the safety of the American public is, of course, at question. As was the case with its sister agency, the Consumer Product Safety Commissions, NHTSA has suffered years of stagnation in funding, and in many cases has endured a reduction in personnel levels, most notably in its important Office of Defects Investigation, ODI. Nevertheless, the agency possesses a number of powerful enforcement tools, many of which were augmented under the Transportation Recall Enhancement Accountability and Documentation, or the TREAD Act of 2000. In addition to being able to compel manufacturers to recall defective vehicles, NHTSA may impose civil penalties for noncompliance and criminal penalties for falsification or withholding of information. This in mind, we must ask ourselves today why these authorities were not used in the case of recent Toyota recalls. Put another way, are the problems with NHTSA's response to the recalls better traced to a lack of authority, or rather to ineptitude and lack of resources? At present, it appears that the latter is more persuasive, although I will not discount the possibility that improvement can be made in the statutes of conferring NHTSA its authority. Our discussion of NHTSA's authorities and resources must not lose sight of what I believe to be malfeasance on the part of Toyota in properly addressing the problems that led to the recall of over 8 million vehicles. To reauthorize NHTSA without a view towards compelling better behavior by automobile manufacturers would be a self-defeating exercise. 2 weeks ago, my questioning of Mr. James Lentz, Toyota head of sales for North America, indicated that all of Toyota's decisions relating to recalls are made in Tokyo. More disquieting is the fact that U.S. officials, the Secretary of Transportation, and the then head of NHTSA had to fly to Japan to persuade Toyota to initiate recalls in the United States. In brief, we must examine how best to oblige automobile manufacturers selling vehicles in the United States to comply quickly and fully with our regulations and law. In closing, I suggest my colleagues bear these comments in mind as we begin what must be the first of many conversations about improving federal oversight of transportation safety. I further ask that these discussions and their resultant legislation will be bipartisan, collegial, and subject to the regular order, for these are the hallmarks of this committee's best work over the years. Mr. Chairman, I thank you for your kindness. I thank our witnesses for appearing before us and yield back the 58 seconds remaining to me.
The chair thanks the gentleman for his extraordinary kindness. It's the normal practice of this committee to swear in the witnesses. So would you stand and raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Let the record reflect that the witness has responded in the affirmative. The chair recognizes himself now for 5 minutes for questioning the witness. Oh, I'm sorry. After the chair's getting ahead of himself. It's been a long day. The chair want to recognize now the administrator because he has certainly some opening statements. So the chair recognizes the administrator for 5 minutes for the purposes of opening statements.
Thank you, Mr. Chairman. To be perfectly honest with you, my statement is not as important as the committee's questions, so I can understand you wanting to hurry up and get to business.
Great beginning, excuse me, great beginning.
Thank you so much for your kind words, all of you. And before I begin my formal remarks, I want to just take a second to acknowledge Mr. Braley and Ms. Schakowsky's note about the human toll. We have a tremendous amount of death on today's highways, and I'm very happy to report some very good news. But 33,000 people is a tremendous amount of people to die, and one person is too many. And the personal toll that it takes on a family is absolutely catastrophic. And in my time that I served as a staffer on the Senate Commerce Committee, I've had the opportunity to spend time with countless victims, including mothers and fathers who have killed their children in unfortunate back-over accidents, and folks that have been disfigured and burned because of traffic accidents, because of defects, and you can never properly capture what this means to people. So I am fully aware of the responsibility that I have, and that every day this agency has one goal. That's to keep people alive and safe on the road. And we can never do that job well enough. We just simply can't. But that doesn't mean that we can't try. And we will continue to put forth maximum effort as we have to make sure that we accomplish the goals. But thank you so much for your observations, and they are taken well to heart. Chairman Rush, Ranking Member Whitfield, and members of the committee, thank you for the opportunity to appear before you today to discuss the Department of Transportation's vision for the future of the National Highway Traffic Safety Administration and its important safety programs. Transportation safety is the department's highest priority. NHTSA's safety programs are an integral part of addressing that priority. Even before I was sworn in as administrator on January 4th, I knew NHTSA's programs work, and they work well. We just released numbers that show a continuing dramatic reduction in the overall number of highway deaths. The Secretary this morning released a report that projects that traffic fatalities have declined for the 15th consecutive quarter and will be 33,963 in 2009, the lowest annual level since 1954. But we must do more. The loss of more than 33,000 people represents a serious public health problem to our nation. We will not rest until that number is zero. So how do we get there? Highway safety is a complex problem, and NHTSA has built a broad spectrum of programs that address both behavioral and vehicle-related causes of highway deaths. The linchpin of all of our programs is good data, good science, and careful engineering. When I was sworn in 2 months ago, I felt it was important to look at whether there was a need to improve NHTSA's effectiveness in this era of the global marketplace and rapidly changing technologies. One of my first decisions was to question whether NHTSA is being well served by the 4 vehicle statutory authorities on which it relies to regulate. The reality is that while current authority does work, and various constituencies have learned to work with them, they were written in the 1960s and the 1970s, when the world and the automobile market were profoundly different. The question I pose, and the questions I want to have, is whether NHTSA's statutory authorities accommodate the modern automobile, the modern competitive marketplace even. More importantly, do they allow us to regulate in a way that allows the industry to build and sell safe products that the consumer wants to drive? Do they allow us to promote safety, innovation, and fuel efficiency while providing effective regulatory and enforcement oversight? I've asked our legal and program staff to take a look at our existing authorities, to answer these questions, and to make their best recommendations. I believe this self-assessment is critical and supports the President's goals for transparency and accountability in government. And while we are taking a hard look at our authorities, I also commit to look at the current ethics rules. I believe the ethics standards set by this administration are the highest ever established by any administration, and I fully support Secretary LaHood's desire to tighten and enforce these rules across the Department of Transportation. If there is any evidence of any violations of these rules, swift and appropriate action will be taken. The next question I ask of NHTSA is, do we have the programmatic expertise that we need to support our programs? NHTSA has a diverse and experienced workforce, and we will take full advantage of their skills, talent, and expertise. If, as we go forward, we find that we need to shore up our workforce in certain areas, we will recruit aggressively. We are currently requesting the authority to hire 66 more people next year, and will target these positions to meet our program needs. Well, at this point, it appears I am out of time, so I'll cut my remarks here. And I thank the committee for their time and their patience, and I stand ready for questions.
The chair thanks the administrator, and the chair recognizes himself for 5 minutes. It's been stated, Mr. Administrator, you know, our goal and the goal of this subcommittee as it relates to NHTSA is to look forward and to determine for ourselves what is the best way that we can assure and assist NHTSA in its primary goal of protecting America's citizens and America's drivers. As I look at this scenario of this Toyota as an incident, as a framework, I wonder about the safety, the quality of the safety of the automobiles on America's highways in general. The question I have is, what reason can you give us, this subcommittee, that we should not think that the recent Toyota recall, that it would not replay itself with any other automobile dealer that puts automobiles, manufactures automobiles for America's highways? What reason can you assure us that this Toyota recall is really just something that is an aberration as it relates to automobile safety?
I would say this, Mr. Chairman, that the Toyota recall, while wide-ranging, is, I think, indicative of how NHTSA uses its authority in a way to get to the bottom of something. When the Secretary of Transportation took office, and at the time it was Acting Administrator Medford, they were observing certain issues with Toyota, and they felt so strongly about it that Mr. Medford went to Japan to inform Toyota that they did not feel that Toyota was holding up its obligations to inform and interact with NHTSA in a way to address safety concerns and recall concerns. That was the beginning. That effort began actually on December the 15th. It was the day of my confirmation hearing, which is a good reason why the entire senior staff regarding defects was actually in Japan and not at my hearing. But better that they be there in Japan explaining to Toyota what they were doing wrong than me sitting in a hearing room here in Washington, D.C. When I took office in January the 4th, I was updated about these issues, and Toyota was at that point beginning to get the message. I again met with them personally for the first time on January the 19th, informing, and I learned about the sticky pedal situation. And they actually executed their stop sale on January the 21st. That effort was because of the analysis of NHTSA, the fast action of the career staff, and the leadership of the Secretary of Transportation. So I don't see Toyota as an indicative example of failure. I see it as NHTSA doing its job. And when our professionals use the data, make the case, and go forward, we get the results that we need. So I think that Toyota, in the wide-ranging recall that it executed, that's the type of response that, frankly, I would want as administrator, and I think that this agency is expecting. And I would hope that in the future that other automakers would do the same in the same set of facts.
Can you give me give the subcommittee any assurances that the automobiles right now, as far as this is concerned, has a level of safety that is greater than what we have experienced with Toyota at this point now?
There's two parts of that answer. First, I will go back to the success that we just had regarding the current data. We have the lowest number of deaths since we've been recording this data since 1954. NHTSA is succeeding in its mission. The second part of your question, do I feel that vehicles are generally safe or will be safe and we don't have any other issue like Toyota? It is the automaker's responsibility to warrant that their vehicles comply with the federal motor vehicle safety standards. That is their responsibility. We are not branding these cars safe. It's our job to enforce and to police the marketplace, which we will do. So as far as I'm concerned, the automakers have to uphold their obligation to not only comply with our standards, but basically the state of the art. It is my job to make sure that they hold to those standards, and this agency will hold that line.
The Chair's time is up. The Chair recognizes Mr. Whitfield for 5 minutes.
Well, Mr. Strickland, thank you again for joining us this afternoon. And as I said in my opening statement, I do think that the agency should be commended because the highways really are safer today than they've ever been from a statistical standpoint. You would agree with that, I'm assuming.
Yes, sir.
Now, we've heard there have been a lot of articles written, a lot of testimony recently that NHTSA has not fulfilled its responsibility. NHTSA is a lapdog for the industry, not a watchdog for the industry. And so there's been a lot of criticism out there about the agency. And as the administrator, how would you respond to that in just a general way? Do you think that criticism is valid or not valid?
No, sir, it's not valid at all. We have been a very active agency since I've taken office. The agency's been very active since Secretary LaHood has taken office. And from my review of the work done on, if we're talking about Toyota specifically, this agency opened 8 separate investigations over the time period when there were complaints about sudden acceleration. A lapdog doesn't open 8 investigations. Now, the goal is for us, and our statutory order is to find any vehicle safety defect that presents an unreasonable risk. Anytime a complaint or any data or any anomaly in the number of complaints or what we see from the early warning system, our folks take a look at it, they go forward and they investigate. If we cannot find the defect, we cannot, under the statute, go forward and force a mandatory recall. But that doesn't mean that we think that vehicle is safe per se. But at that point, we cannot make the statutory case. But we will keep looking. And as we keep looking, and when we find a defect, such as in the instance of the floor mat entrapment, or the instance of the sticky pedal, or in the instance of the 2010 Prius brakes, we act and we act quickly. I don't think that the history of our action in this area before I took office, or in the 10-year period that a lot of people are looking at, I think that this agency has been quite active.
Okay, now, if you find a defect, then you can require a mandatory recall. Is that correct?
Yes, sir, we can.
Okay. And I've heard a lot of discussion about subpoena power, and it's my understanding that you all have that you can issue information requests.
Yes, sir.
And do the manufacturers have to respond to that request? Is it?
Yeah, there's a difference between a subpoena and an information request. I know a lot of people talk about we have subpoena power, and yes, we can compel a subpoena for documents. We say we want to give every document you have on a question, and yes, they have to give that to us. Information requests, they also have to respond, but it has actually a better purpose. We not only get documents, we actually ask direct questions that they give us answers to. It's a much sharper tool, and the agency uses that quite frequently. In fact, we sent 3 queries to Toyota, 3 large queries regarding the timeliness of their submission of information to us regarding the floor mats and the sticky pedal. And we sent a large recall query asking Toyota for all their information and to answer questions about all of sudden acceleration incidents, which will be a large amount of documents and data for us to review. If we find in the review of those documents that there is a violation, we will move forward accordingly.
Have you found the lack of subpoena power a hindrance to the agency doing its job effectively?
In my review of the work on Toyota, they have been able to, while Toyota has been slow in years past, I will say that they have not been as responsive as my career staff feel they should have been in responses. Since I have been in office, they have been very responsive, and I would hope that that would continue in the future. But in terms of the ability, our subpoena power, our ability to get information requests issued and responded to, I've gotten no evidence that that has been a problem in terms of getting a response.
Now, I know most of your budget money goes to the states for grants, and then the rest is spent basically between behavioral science or behavioral safety and vehicle safety. Is that correct?
That is correct, sir.
And I know that in 2005, Congress directed NHTSA to conduct a national motor vehicle crash causation survey. Mm-hmm. And at that time, it came back and it said that 95% of crashes were due primarily to driver fault or negligence. Are you familiar with that study, or do you have any thoughts on that?
I am tangentially familiar with it. I can't give you song, chapter, and verse about the study, but I can talk in more specifics about behavior. That is the largest component of risk on the highway, which is the reason why the NHTSA budget is designed to attack the highest risk. Mm-hmm. Impaired driving, not wearing belts, driving distracted. Those are all the hugest risks for everyone on the road today. Vehicle defects are important. We have to address them. They are significant. But in terms of the overall risk profile for highway safety, the behavioral side of the house, so to speak, comprises the largest risk, and that's the reason why our program for safety is designed the way it is.
Thank you.
Thank you, Mr. Whitfield.
The Chairman Emeritus is recognized for 5 minutes.
My questions, in view of the time shortage, you're going to have to require yes or no answers.
Yes, Mr. Dingell.
Mr. Administrator, do you believe that the NHTSA made mistakes in its response to the recent Toyota recalls?
No, sir, I do not.
Should NHTSA have pushed Toyota to initiate recalls earlier than it did?
We pushed we pushed the recalls when we had the evidence of an unreasonable risk defect. So.
All right. But yes or no?
The answer is yes, we have responded appropriately.
Okay. Thank you. What authorities does NHTSA lack, whether under TREAD Act or otherwise, with which to address defects in automobiles deemed hazardous to public safety? Please submit that answer for the record.
Yes, sir.
Now, yes or no? Does NHTSA have in place a ranking system for determining the priority of defects investigations? Yes or no?
The answer is no, but we rank risks by profile internally. There isn't a 1 through 10.
Thank you. Now, there seems to be broad agreement about the need to increase resources available to NHTSA to carry out its mission. Do you need additional resources, yes or no?
The President's budget gives us more resources, so if the President's budget is passed, we will have the resources we need.
All right. Please submit to us for the record how much more resources you need in what area.
Yes, sir.
I want that submitted directly to the committee and not through OMB.
Yes, sir.
Now, in my questioning of James Lentz, Toyota's chief of sales for North America, he revealed that decisions to recall Toyota vehicles sold in North America are made in Japan. Do any other manufacturers require that your information for details or that decisions made relative to recalls are made in any country outside this United States? Is Toyota unique in that, yes or no?
It appears Toyota is unique, yes, sir.
All right. It strikes me that this is a bad situation insofar as safety of the American people. Am I correct or wrong?
The system that Toyota uses could be much more efficient.
Okay. By requiring them to have a response to be made in the United States by somebody empowered to comply with our laws. Is that right?
I would feel that if they had somebody in America to respond directly, we could act more quickly with them. Yes, sir.
Now, I would appreciate if you would submit to us for the record how this would be corrected. Now, is there a quantitative difference in response times between domestic and foreign automobile manufacturers to NHTSA's data inquiries? Yes or no?
The domestic manufacturers tend to respond faster than the foreign. Yes, sir.
What is the cause for this?
There are several reasons in terms of design, of leadership, as you mentioned, and other factors.
In the case of Toyota, it's because the information has to be procured from Toyota instead of receiving it directly from here. Is that right?
That has been identified by Toyota itself as a problem.
This is also true with regard to the question of recall.
Yes, sir.
The decision is made in Tokyo.
That is correct.
Now, is there a qualitative or quantitative difference in the data provided to NHTSA by domestic and foreign automobile manufacturers?
The quality is, because they're statutorily required, the quality of data is very similar between foreign and domestic.
Similar?
Similar.
That doesn't mean it's the same.
They have different data sets because of their manufacturing and information processes. They comply to our system, so they are similar.
All right. Now, why was it that the Secretary of Transportation and the and the acting head of NHTSA had to go to Tokyo to get cooperation of Toyota on recalls and production of information?
They were responding to NHTSA and the acting administrator and the secretary too slowly.
Well, they had to go over there. Why did they have to go over there?
Because at the time, the secretary and the acting administrator felt they needed to go directly to convey that message.
So they had to convey that message because the message was to urge Toyota to comply more expeditiously with the safety concerns of
that is correct,
Department of Transportation. I'm sorry?
That is correct.
Okay. So they had to do it to get more expeditious cooperation from Toyota.
Yes, sir. That's correct.
Thank you. Mr. Chairman, I thank you for your courtesy.
The chair now recognizes Ms. Schakowsky for 5 minutes for questioning.
Thank you, Mr. Chairman. On September 1st, 2009, proposed rules were put out dealing with the automatic reverse system on Windows. Let me quote. NHTSA proposes requiring automatic reversal systems, ARS, in those windows equipped with one-touch closing or express up operation. In a letter, March 10th, 2010, that is sent to you, Mr. Strickland, it was Henry Waxman, Chairman Rush, and myself point out that such windows generally already have auto-reverse technology and are usually found in the driver's window where children don't sit. And the intention of the legislation, of course, was to protect children. But here's really the point I want to make that I find stunning, is that you have a chart. This was alternative 1 of 5 alternatives that were proposed at that time. This is before your tenure. Alternative 1 is the one I described. And when it says on this chart, cost per window for this remedy, supposedly, it says $0, total incremental cost near $0, annual fatality benefits $0, annual injury benefits near $0. So the preferred alternative to protect children was a no-cost, no-benefit solution. I would have thought it embarrassing, actually, not only to put that in writing, but to choose that as the preferred option. I would hope that nothing like that happens again. Let me describe alternative 2, requiring auto-reverse windows at all power side windows to meet ECE 21, which is European standards. The cost per window, $6, which I think most people would find reasonable. The total incremental cost, $149.4 million. Annual fatality benefits, 2. Annual injury benefits, $850. So 2 deaths and 850 injuries, which I think is pretty modest projection, pretty conservative, could be saved. That was at $6 a window. Again, I want to go back to those families that came talking about children who were choked by these windows. It's got to be maddening to them that this is something that could have been corrected for $6, and that is the European Union standard. Why isn't it the standard here? So really, my request is that we reject this alternative 1, but how does that happen? Can we expect that it will not happen anymore, that a no-cost, no-benefit solution will not be proposed?
As you know, Representative Schakowsky, I can't engage in a discussion about a rule that is currently being worked on by NHTSA. But I understand that we have received new data from a lot of constituencies, including the folks that have worked very closely with you and other members on the Cameron-Gold-Branson Act, and the agency is taking a very hard look at that data. And when the rule is finally promulgated, we hope that we will be, I know for a fact it will be based on sound data and sound science that will be the most efficacious of safety. So that's the one thing I can tell you.
Well, let me make a very strong recommendation that you don't propose rules that have absolutely no effect when the Congress stated very clearly that we want to protect children. And I'm sure you'll agree with that, so I thank you very much. And I yield back, Mr. Chairman.
Thank you, Representative.
The chair recognizes the gentleman from Iowa, Mr. Braley, for 5 minutes.
Thank you, Mr. Chairman. Mr. Strickland, in your opening statement that we received, the written statement, on page 1, third paragraph, you wrote, "One of the first questions I asked when I became the administrator of NHTSA is whether our current statutory authority, drafted largely in the 1960s and 1970s, is sufficient to address the modern automobile and global automotive marketplace."
Yes, sir.
Have you answered that question?
That question is still being worked on by the staff. I have a great deal of experience in looking at consumer product safety statutes from my prior employ, and you have to be very careful in examining these things, in that we have to make sure that there is a lot in those statutes that are very functional and works well, and we want to look to improve upon a strong authority. And my staff, both my legal staff and my programmatic staff, are undertaking that work right now. When we've completed that work, we will be happy and excited to share our thoughts with the committee, and looking forward to working with you on a going forward basis.
And I look forward to having that conversation. And let me get back to one of my earlier points about the legacy of the agency that you now head.
Yes, sir.
Because in your statement you noted correctly that safety is the Department of Transportation's highest priority. And you stand by that statement today.
Yes, sir, absolutely.
And we know that the Office of Defect Investigation often referred to by its acronym ODI, is on the front line of defect investigation and prevention as part of the Department of Transportation.
Yes, sir, that is correct.
And Mr. Whitfield asked you a very appropriate question when he said you have mandatory recall power, and you answered yes. Do you remember that?
Yes, sir.
Can you explain to all of us then why your agency, NHTSA, has not initiated a recall since 1979?
Because you can often influence a recall by going through the initial stages of the process. Most times, an automaker will not want to go through the full formal process. It takes approximately a year. It's a public process, and a lot of automakers, realizing they are facing public scrutiny of fighting a vehicle safety defect, and when they know that the agency can prove it, they will go forward and effectuate a voluntary recall. The universe is that most recalls are voluntary. All recalls since that period of time are voluntary. But there's a huge number that are influenced by this agency, and that's the actual number that one should look at. And we influence well over half of the recalls that are happen every year. So that's the real number, Mr. Braley, I think, that is indicative of the power of ODI. We don't have to get to a point where the administrator, after a year of public hearings and show cause hearings, has to sign an order. Automakers will go forward and take care of that recall voluntarily from ODI's work.
Well, count me as skeptical that in a 31-year period, there has not been an instance where automakers acted responsibly in every particular case responding to demand for recall of a product defect in a 31-year period. One of the things that I also want to talk to you about is how you described the agency's mission has changed in response to changes in the automotive industry. Do you remember that in your opening remarks?
I don't think I would call it a change in mission, but it's a change in how we have to approach the job because of the change in the marketplace. There was a time when America was the world's leader in automotive manufacture. We are no longer that leader.
Well, I'm talking about something different, so I want to make sure you understand.
I apologize.
Okay, when I was growing up, it was during the muscle car era,
yes, sir,
where you could tear apart a Chevy large block engine in your basement and put it back together, having a basic knowledge of the internal combustion engine.
Yes.
You cannot do that anymore. Would you concede that?
I agree. Yes, sir.
And one of the things that came out during our earlier hearing was this concept of black box technology that has crash data in it that is driven by complex computer code, sometimes which the manufacturer is willing to share with your agency, and sometimes manufacturers have been very reluctant to share that data or to provide an ability for your own employees to have the keys to the kingdom so that they can download and interpret that information independently. You would agree with that?
Yes, sir, I agree.
So one of the things that I'm concerned about is our own internal committee report for this hearing suggests that your agency's budget dedicated to vehicle safety has remained stagnant relatively over the past 10 years, and that your resources are far below the resources that were available for this type of investigation than when the agency was at its height. And my concern is, based upon some of the testimony at the previous hearing, when you have a demand for computer engineers and electrical engineers and people who are not based on mechanical backgrounds, I'm concerned that the level of funding and the staffing of personnel within your agency may not be adequate to meet the incredible demands of the changing technology of this automobile industry. Have you done an independent review since assuming responsibility to make your own independent judgment on whether or not that is a critical case we need to address?
I have a couple of responses to that, Mr. Braley. The work of ODI and the automotive engineers that do the work, they are some of the finest in the business in this country. And as the technology evolves, the experience of our investigators and our engineers also evolve. I can give you the quantum number of folks that we have on deck to do the job. We have 125 engineers of all of NHTSA. We have 5 electrical engineers. We have a software engineer. We have engineers that are based in our East Liberty, Ohio facility. We have resources for consultants when we need additional, expertise. And from my understanding, from what I know from when I've taken office, there is not a notion that we don't have the proper, expertise to handle today's automobile. I don't think that's the case at all. However, recognizing that you can always buttress what you have, the President has provided us resources to hire 66 new people, which we will use to leverage our resources and to buttress and strengthen those folks. In addition to, we will be looking at ways that how we can do longitudinal studies and long-range studies on these complex systems, as the Secretary spoke about in the prior hearings. Is my confidence that we handle the current marketplace with our expertise? Yes, we can. Can we be stronger in that area? Of course we can.
Of the 62 employees you've identified that are in the President's budget request, how many of those do you propose to allocate to ODI?
That's part of that. That's an undergoing process. I'm working with the career staff and with the Office of the Secretary to figure out what our resource needs would be in that area. I will be happy to come forward with that information when the decision is made.
Can you also provide the committee with a breakdown of the people working at ODI with engineering degrees by their names, their job titles, and what their particular expertise in terms of being a professional engineer is?
Be happy to do that, Mr. Braley.
Thank you. I appreciate that, and I yield back.
The chair recognizes now the gentlelady from Michigan, Ms. Sutton, for 5 minutes.
Thank you, Mr. Chairman.
Ohio,
I'm
sorry.
close to Michigan, but I'm from
Ohio, 5 minutes. Again.
That's okay. Administrator Strickland, thank you for being here. I have a number of questions, and they touch on different areas, so bear with me as we shift around. Beginning with the question of the black box technology, we've heard a lot about when Secretary LaHood was here, he indicated a difficulty getting the information that is in those black boxes, that we don't have the capacity, whether it is, as my colleague Mr. Braley describes, that we don't have keys to the kingdom, which is that information. But when I heard you answer Representative Dingell about having access to data, you said we have access to data in a similar way, whether it's Toyota, who keeps information in Japan, and our domestic auto industry. But I was under the impression, based on the last hearing, that we actually could access information from our domestic auto manufacturers in a way that we can't get from Toyota. So could you clarify for me?
Happy to clarify. I took from Mr. Dingell's question about early warning reporting data, which is the quarterly data we receive from all automakers, which is a set template of data that we receive. There are some differences in how they collate and present it, but we can understand all of that. That's what I thought he meant. Okay. In terms of event data recorders, you're absolutely right, Representative Sutton. Toyota has a proprietary system that up until, I guess, a week or so ago, there was only one tool in the country that could be used to read it, and we did not have that tool. So if we ever wanted to get information from an event data recorder on a Toyota vehicle, it was very difficult. It is my understanding that Toyota has provided my ODI staff 3 of these tools to read. Their event data recorders. I am not sure the status of whether we have received them all yet, but that's my understanding that Toyota has promised to us that they would provide those tools. So in terms of Mr. Dingell's question, in terms of the set data that comes into us quarterly from all automakers, yes, it's similar. On your question on event data recorders, yes, there is a difference between the Detroit automakers, which all use a commercially available tool, and we have the ability to read it, versus Toyota, where we could not up until a week ago.
Okay, and now that you have this equipment, that was the only hindrance to having access to the black boxes. You can get them. You can always get access.
We can access it, Representative, but we still need a Toyota representative to help decode the data. It isn't fully transparent even when we download the box. So I still believe that we do have Toyota representation to assist us in decoding what happened 5 seconds pre-crash and 1 second post-crash, I believe, is the data that's being included on those boxes.
And is that something that they're required in any way to do, or is that just a voluntary
everything is
offer on their part?
At this point, we are undergoing a rule by 2012. It is if an automaker chooses to have an EDR on board, it has to comport with certain readability and data standards. But they don't have to have an electronic an electronic data recorder on board. It is not mandated.
Well, that's interesting. We'll have to follow that and see what the consequences intended and others are of that rulemaking. And okay, with respect to what we've been reading in the Washington Post about the relationship between some of those who used to work at NHTSA and going over to work for some of the car companies, and in this moment, Toyota is in the headlines. And so the Post article mentioned that 2 former NHTSA defects investigators left the agency and immediately took jobs at Toyota managing federal defect investigations. And do you think that there is an apparent conflict of interest here? You know, we're charged with, as members of Congress, ensuring that the public interest is always the key. And you can understand that people are a little, more than a little, concerned when they see sort of that cozy, quick turnover revolving door. Could you comment on that?
Certainly. I have 2 responses to that, Representative. No ethics laws were broken. You know, Mr. Santucci and Mr. Tinto, who are former employees of NHTSA, when they left in their post-employment, they were of the level of employee. Everything that they did was fully compliant with the current federal laws regarding post-employment limitations. So no laws are broken. But I'm not going to quibble with you on appearance. Perception is reality. And the Secretary was very clear in his statement to this committee and to Oversight and Government Reform and to the Senate Commerce Committee on this issue. He is committed to strengthening the ethics requirements in the Department of Transportation. I fully support his efforts, and as far as I'm concerned, I'm going to hold every employee in NHTSA to the highest ethical standard, as the Secretary holds everybody in DOT to the highest standard, and frankly, the Obama administration has made it a focal point that this will be the most ethical administration in history. So as far as we are looking forward to working with you on a going forward basis and dealing and handling this issue of appearance and arm's length distance between for employees of NHTSA and when they move into a post-employment situation.
I appreciate that answer because the public trust is critically important and making sure that things are working as they should. And if I could just, Mr. Chairman, if I could just indulge in one last question. During the hearings that we've had in the past with representatives of Toyota and Secretary LaHood, we heard information about how recalls of vehicles had happened in other countries, and these recalls, stemming from what appear to be problems that arose here in this country and led to eventual recalls after much tragedy had occurred. Is there anything that requires auto manufacturers to report to NHTSA problems beyond our borders with vehicles that are sold in this country?
Yeah, there's a couple of requirements actually. They have to report to us foreign recalls that involve components used in the United States vehicles, and they have to also report foreign service campaigns and that happens in vehicles. Now the question is whether they did this timely. We definitely will investigate those issues, but we receive a lot of data from the early warning system and other obligations from the TREAD Act, and we're definitely looking at other ways, that other types of information that could be helpful to us in that mission, and we're looking forward to working with the Congress and finding ways that we can buttress those abilities.
The chair requests, we see Mr. Marquez joined the subcommittee. He's not a member of the committee, so the chair seeks unanimous consent that Mr. Marquez be allowed to ask questions of the witness, and hearing no objection, so ordered. Mr. Marquez, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for your hospitality. As you know, the early warning system that I helped to create during the 2000 TREAD Act was intended to provide the Department of Transportation and the public with early information that auto manufacturers receive about safety-related complaints. But the Bush administration issued a regulation that deemed almost all of the information automakers submit to be confidential business information. As a result, As far as the public is concerned about my provision back in 2000, the early warning system has become an early warning secret. I have a summary here of the public information contained in all of the early warnings submitted by Toyota in the last quarter of 2008. It tells you that there were 7 reports of deaths or serious injuries due to speed control, but that is all the information you get. The public can't learn whether those reports relate to sudden unintended acceleration. They can't learn what happened, and they can't learn whether any consumers made complaints about similar problems that didn't result in a serious injury or death. Do you agree that the public versions of early warning system data don't really tell the public anything specific or useful about potential automobile safety problems?
Mr. Markey, the one thing I'd like to start off with saying is that the NHTSA databases and the information we provide are some of the most transparent in government, and we've been noted by the federal government about our data sources that we provide. In terms of the early warning system, as far as the Obama administration is concerned, as far as I'm concerned as administrator, the more transparency we have, the better. I'd definitely like to have a dialogue with you about the early warning reporting system and your thoughts on how we can improve transparency going forward.
Now, consumers can report safety complaints to NHTSA as well, and these reports are made public. Does it make sense to you that when a consumer reports a safety problem directly to NHTSA, it goes into a publicly searchable database, but when a consumer, not knowing that they could complain to NHTSA, instead reports the safety problem to a car company, that it becomes confidential business information without a requirement that the public learn about it? Do you think that's right, or do you think that that information should as well have to be made public because it's given to NHTSA as part of a public report?
I clearly see that inconsistency. This administration believes in transparency, would happily talk to you on a going forward basis how we can make our databases more transparent.
Do you think that information should be information that the public, me as an owner of a Toyota Camry, should I have had that information?
That information should not be hidden in my personal opinion. However, there's other things that should come into play, and I'm happy to talk to you on a going forward basis.
When President Clinton signed the act into law, he directed the Department of Transportation to implement the early warning system in a manner that ensures maximum public availability of information. That clearly hasn't happened. So my goal is to work with you, sir, in order to accomplish that goal. We thank you for taking this job, by the way.
Thank you, Mr. Markey.
And we've enjoyed working with you over all the years, especially on the fuel economy standards and your work in the Senate.
Thank you.
And let me ask, if I may, one final question. Although NHTSA can undertake a mandatory recall, doing so takes a great deal of time and can require you to go to court to prove the existence of a safety defect. There are times, however, when taking that long costs lives. As you know, since you were the lead staffer in the Senate 2 years ago, Congress gave the Consumer Product Safety Commission the authority to quickly inform the public of an imminent product safety hazard, even though the formal recall process was complete. Do you think that sort of authority could help NHTSA more effectively protect and inform the public of serious safety problems, and will you work with us to develop such a provision?
The Imminent Hazard Authority, Mr. Markey, is and several of our sister consumer product safety, consumer safety agencies. The Federal Rail Administration, for example, has this authority, and it's proven to be very helpful to them. I look forward to working with you and having a further discussion on this authority. It has proven very successful in other areas of consumer protection, and it may bear fruit for NHTSA as well.
Thank you. And our country is very fortunate that you were willing to accept this position.
Thank you, Mr. Markey. It's very kind.
Thank you, sir.
The chair will ask the indulgence of the witness just for a few more minutes. The chair will authorize a second series of questions, and the chair recognizes himself for 2 minutes. So, NHTSA's budget for vehicle safety programs has been stagnant as was mentioned earlier, for the past 10 years. From my perspective, this year's budget request is down a few $1 million from the year before. ODI, which focuses its enforcement activities on new cars sold within the last 5 years, has a budget of less than $10 million to police a fleet of 80 million vehicles, and that, according to the Chicago Public Schools, adds up to about 10 cents a car. The budget for rulemaking is suffering as well. It has delayed major rulemaking efforts to the point that Congress has been compelled to legislate mandates for rollover standards and for child safety. The agency is, as far as I can see, NHTSA is starved, and the impact of the starvation is pretty clear. I know that there's an increase of about 66 new personnel, but if you get more resources for your safety programs, where would you focus those increased resources?
Well, Mr. Chairman, you know, the safety mission is not simply in the ODI or the vehicle safety office. It is actually across, it's our entire mission. It's the behavioral side as well. And the President's budget provides resources for us to accomplish our mission with the new resources for those personnel. We will take a hard look at those 66 personnel and deploy them at the places where we need, not only to improve and strengthen the Office of Defects Investigation, but in other places where we can also help further our safety mission in the most efficient way. In terms of, you know, resources overall, we have accomplished our mission with the resources we have had. The President has given us a budget that gives us more resources to do more, and we will use that for the safety mission.
This Congress has to prepare a budget. The President set a budget. The Congress has to approve a budget, and we certainly will be looking at need and not greed.
Yes, sir.
Would you have any objections if we gave you more than a budget for 66 employees?
Mr. Rush, the President's budget helps us accomplish our mission. If the decision of the Congress is to provide us more resources, we will use them judiciously for the purposes of improving safety.
Sounds like a good answer to me. All right. Mr. Whitfield, 2 minutes.
I would just say I don't know how much more money we have to give you, but thank you.
Okay, with that said, and seeing no more members seeking recognition, Mr. Administrator, you've done an excellent job. We thank you very much. And again, please forgive us, but our duties have taken us away, and so we weren't able to be as prompt as we wanted to be as we beginning this hearing. So thank you for your patience.
No, thank you, Mr. Rush. It's been an honor. Thank you, sir.
Thank you.
Mr. Whitfield, thank you.
The second panel will please be seated at the desk. The chair thanks the second panel for your patience, and again, we want to reemphasize our apologies to you for our schedule today. It's been fairly horrendous, and it's taken us away from our scheduled duties, the votes on the floor, And so please accept our sincere apologies. The chair wants to introduce the witnesses now that comprise the second panel. On my left is Ms. Joan Claybrook. She's the former administrator for the National Highway Traffic Safety Administration. And Ms. Claybrook, we want to welcome you here once again. Right? Seated next to Ms. Claybrook is Ms. Ami Gadhia. And Ms. Gadhia is the Safety Policy Council for the Consumer Union. And Ms. Gadhia, we want to welcome you also to this hearing. And lastly, we want to not just recognize, but we want to also say hello to our former colleague who was a member of this House, a very able member representing the state of Oklahoma for many years, a very bright and intelligent human being, the Honorable David McCurdy, who is the president and the CEO of the Alliance for Automobile Manufacturers. And Dave, it's good to see you again, and we welcome you again to this subcommittee's hearing. Now we want to recognize for 5 minutes for the purposes of an opening statement the illustrious Ms. Joan Claybrook.
Thank you so much, Mr. Chairman. I am the last person to have required an auto company to do a recall, and that was 31 years ago. And I would like to say that when you do find a defect, the auto companies will often do a recall, and you do not have to go to court. But sometimes you do have to go to court. And I think that there's been, and the Toyota case, I think, elaborates on this. I think there's been a misconception on what a defect is. And in the last case that was litigated by the Department of Transportation on this issue, the Federal Court of Appeals made several important comments, which I would just like to mention to you. This is not in my testimony. I hope that my whole testimony will be in the record. But I think that this is a very important issue. It's come up now several times in recent days. What the court said was, to find a defect within the meaning of the Act, the NHTSA must show that the vehicle itself is defective, whether the defect manifests itself in performance, construction, components, or materials of the automobile. In other words, it can be a performance defect, and they do not have to show that there are 5 or 500 or 10,000 consumer complaints that have arisen. And often, in fact, those complaints are not allowed in court as evidence. So if the agency relies on it, then it's not going to have them find a successful result. Judge Leventhal, who was a Court of Appeals judge in a different case, said that a determination of a defect does not require any predicate of identifying engineering, metallurgical, or manufacturing failures. A determination of a defect may be based exclusively on the performance record of the vehicle or component. So I think that this changes, if you look at the Toyota case, and I know this is not just about Toyota, but it's about the agency. It changes the way the agency should approach these defect investigations. And I do think that the agency has fallen into a trap, if you would, with the Toyota case and others, where it seems to be accepting the burden of having to define what the defect is in terms of the failure of performance. That's the responsibility of the manufacturer. The manufacturer put that vehicle together. They did the design drawings. They make the profit from it. And how this happens is their responsibility. If it has a failure in performance, the agency can find a defect, and the company has to fix it. And the company has to figure out what that fix is. That's what the courts have said, and I think it's very important to make that clear. My testimony that I submitted has 7 points that I would like to just mention very briefly. One is that there has been a low priority on enforcement in the agency, a lack of resources, which you all have discussed. But there's another key issue, which is that a court of appeals in the mid-1980s found that consumers did not have authority under the existing statute to sue if a defect was not found by the agency. In other words, if a case was closed, there was no authority of consumers to go to court. There is authority for consumers to go to court if a rulemaking decision is made that we don't think is proper. And we, in fact, have gone to court at Public Citizen on many, many occasions and helped to make the statute work better because of the cases that we have brought. We've brought them on uniform tire quality grading, on the tire monitoring system for the amount of inflation in the tire, on the early warning system, which was kept secret. Totally secret. We at least got part of it revealed in 2 different lawsuits. So we can sue when there's a rulemaking issue. We cannot sue when there's a defect is closed. And I think that changes the balance of thinking by the administrator. There's no fear that if they close a case that it's finished. And what the court there said in the Court of Appeals in the mid-'80s was that that the agency had the discretion to figure it out according to their resources. And so in every case that NHTSA closes, it says it closes it on the basis of resources. They just are mimicking the words of the court decision. But the fact is that we should have that authority because it should be, we're not going to bring cases we don't think we can win because that's a waste of our time and energy. And I think there ought to be a better balance of power because if the agency finds a defect, then the company gets a chance to get its words and say what it thinks. And if we bring a case, they can intervene. Secondly, the agency has been engaged in excessive secrecy. The early warning system, which Mr. Markey talked about, is a good example. And as I said, we had to sue to make it available. We don't even know how many times Toyota, in the recent cases, filed an early warning report to the agency and what it said, and how many consumer complaints it had, and how many warranty claims it had, and how many field reports it had. All of that is secret. And if that were more open, then the public would have access to it, and they could help the agency by letting them know when they had a problem. But their web page, in addition, is a mess. And so if you went to the web page to try and figure out whether there have been early warning reports on a particular vehicle that you're driving that is not working right, you wouldn't be able to figure it out. I wouldn't be able to figure it out. The third point is that I think the penalties that the agency has authority to impose are insufficient. First, they should have a criminal authority for knowing and willful violation of the act, which is you put in the CPSC law most recently a year ago. It's in the FDA law. It's in many of the sister agency laws. I think the same should be available for NHTSA. And in addition, the penalty for the civil penalty is $16.2 million, which is a fly speck for companies like Toyota. They spend that much in half a day on their communications activities and staff. So we think that it ought to be $100 million because that's something that they would pay attention to. Fourth, the agency is drastically underfunded. The total budget for the motor vehicle program for the whole United States is $132 million in this agency. That's it. And it's not much above what it was when I was there, just in dollars, and in terms of inflation, it's way below. It has been drastically cut. By the way, those 66 new FTEs that were being discussed, it's actually only 33 full-time ones. So that's not really 66. And in addition, they have allocated them. 23 are for operations and research, 8 for rulemaking, 4 of them for enforcement. So that's the tentative allocation. Now, they may be changing that and reconsidering it, but that's what was in the budget. So the agency cannot handle the programs, the rulemaking programs, which are critically important, as important certainly as the defect enforcement, because of lack of capacity. Information gathering and the data systems are totally insufficient. They should have been funded at 4 or 5 times what they are now, given the design of these systems back when they were first created in the 70s. I think that a key issue that has come up at this hearing to some extent is the black box. It's a voluntary standard. Voluntary standards don't work, as evidenced by the fact that Toyota, his system is not even being made available. And the deadline for compliance was supposed to be 2010. It was extended to 2012. So it's delayed so it's a 5-year lead-in for a voluntary standard, which is ridiculous. And we think the black box ought to be mandatory, and that the data have a standardized downloading for the data, so that the police don't have to have 7 different computers, depending on whether it's a General Motors car or Toyota or Nissan or Mercedes. They ought to have one standardized downloading system. And I think that a way that the agency could be drastically enhanced, it's very exciting, would be to have that black box data when it is downloaded when a crash occurs, a serious crash, a tow-away crash, or an airbag crash, to have that data go to NHTSA, have NHTSA set up a data system to receive it, so that that can be the basis for their evaluation of defects and evaluation of safety standards. And the data would be voluminous, and it would be fabulous, and far more than what they have today. And it would be much less expensive. So I hope that the committee will consider that issue as well. The new safety standards should come out of some of the work that goes on in the defects area. For example, for years, NHTSA has tested cars and seat backs have failed when they hit them in the rear at 30 miles an hour, and yet they've never issued a standard to upgrade that seat back. It's a very dangerous circumstance. If the seat back fails, you can't control the car. And you also, many people become quadriplegic and paraplegic as a result. But in the Toyota case, I think a brake override standard and a brake override standard and a new accelerator standard, which was issued in 1973 and is not even electronic, so it's completely irrelevant to the current models, should be done. And then finally, I believe that conflict of interest rules need to be strengthened, as we've mentioned. And I would mention that NHTSA has a test facility in Ohio, but it's owned by Honda Motor Company. I created this back in the 70s when it was owned by the state of Ohio. Now it's owned by Honda because they bought it. And I think that should be changed. They should change their facility, and there's some opportunities for doing that. Thank you very much, Mr. Chairman. I have several submissions for the record. I'm sorry that I slightly overwent my time.
The chair, by unanimous consent, will accept the extraneous material and your full statement into the record.
Thank you, sir.
Ms. Garcia, you're recognized for 5 minutes.
Thank you. Chairman Rush, Ranking Member Whitfield, and members of the subcommittee, thank you for the opportunity to testify on the road ahead for NHTSA. I am Ami Gadia, Policy Counsel with Consumers Union, the nonprofit publisher of Consumer Reports. The recent Toyota recalls involving sudden unintended acceleration have focused national attention on safety problems. Consumers Union believes that addressing this formidable challenge demands a coordinated effort by the government, automakers, the public, and independent consumer groups such as our own. We recommend the following government actions to improve our auto safety net. Consumers Union believes government regulators could have moved more aggressively to pursue sudden unintended acceleration and to protect consumers' safety. Various news reports and our own analysis of documents from the investigation point to a pattern of missed opportunities. NHTSA and Toyota were aware of unintended acceleration complaints involving Toyota models as early as 2003, when the agency received a petition to investigate the problem. We are pleased that NHTSA is now looking into potential electronics issues behind the events involving Toyotas, and we eagerly await the agency's findings. However, we believe that NHTSA can take actions now to improve safety. First, we would like to see improved public access to safety information. NHTSA's Office of Defects Investigations collects complaints and data about autos from the public and manufacturers in 2 separate databases: the Consumer Complaints Database and the agency's Early Warning Reporting System. But both have limitations, and the data they provide are not integrated, making it more difficult for investigators to spot issues and for consumers to find information. Consumers shouldn't have to visit different sites to see all of this information or be forced to search it using tools that are less than user-friendly. All complaint information should be visible via a single, easy-to-use, consumer-facing site. NHTSA should also initiate a program to raise public awareness and invite more drivers to participate in data gathering. The more public complaints there are to analyze, the greater the chance that problems such as unintended acceleration will be identified at an early stage. Second, NHTSA should promulgate certain safety regulations to prevent sudden unintended acceleration in all automobiles. They should require that cars be able to stop within a reasonable distance with a sustained press on the brake pedal, even when the throttle is fully open. One method to reduce stopping distances is smart throttle technology that allows the brakes to override the throttle. Other methods may also become available. To us, the most important safety feature is to ensure that a vehicle can stop within a reasonable and safe distance. NHTSA should require simple, standard controls that can easily turn off the engine in an emergency. In many current Toyota vehicles, when the car is moving, it requires a sustained 3-second push of the button to turn off the engine. Though that is a safety precaution to prevent accidental engine shutoff, it is an action many owners may not be able to do in a panicked situation. Ignition controls should be easy to operate, especially in an emergency. NHTSA should require intuitive, clearly labeled transmission shifters in all cars. If your car is accelerating out of control, hitting the brakes and shifting into neutral is your best strategy. But you want to know where neutral is when you are panicking. There should be consistency for shifters across all vehicles. NHTSA should also require a minimum distance between the gas pedal and the floorboard. Floor mats that entrap pedals have been a major focus in recent recalls, but people frequently use thick mats or ill-fitting mats or stack the mats on top of each other. NHTSA should ensure that there is sufficient clearance between the pedal and the floor mat. We also think that NHTSA's cap on civil penalties should be lifted to act as a deterrent against future violations, and that NHTSA could improve the recall compliance process. The average consumer response rate to vehicles is 74.1%. Currently, manufacturers notify dealers about recalls, and the dealers, in turn, notify car manufacturers once the cars are repaired in response to a safety recall. Consumers Union suggests that going forward, car manufacturers submit such data to NHTSA. This information, which manufacturers already have, should include individual vehicle identification numbers, or VINs, of cars that are subject to a particular recall, as well as when the recall repairs were performed on the vehicles. NHTSA would then be able to match up safety recalls with the manufacturer-provided VIN in a consumer-friendly, searchable database. We would further encourage states to consider linking safety recall compliance with the ability to obtain a vehicle registration, similar to the way consumers must show proof of insurance to register their cars now. This would help people who purchase used cars to know whether recall repairs have been made. We also recommend that Congress take a look at the reports of a revolving door at NHTSA and whether this may have impacted safety decisions. We are pleased to hear today the administrator's comment that the administration will be looking, that NHTSA will be looking into this particular issue. Finally, we urge Congress to adequately fund NHTSA. In 2007, motor vehicle crashes accounted for 99% of all transportation-related injuries and fatalities. Yet NHTSA's budget currently amounts to just over 1% of the overall DOT budget. The agency's budget and staffing for auto safety and consumer protection functions should be commensurate with the realities of traffic safety. Consumers Union thanks the committee for the opportunity to present its recommendations as you move forward.
Chair thanks the witness. The chair now recognizes Mr. McCurdy for 5 minutes for the purposes of an opening statement.
Thank you, Mr. Chairman and Ranking Member Whitfield, for the opportunity to appear and speak on behalf of the industry as a whole. I must admit, as you made your introduction, there was some chagrin on my personal part when I looked at the membership of this subcommittee, in that I actually served with the fathers of 3 of the members. So it is a homecoming of sorts, but I hadn't thought I'd been gone that long. But, it's good to be back with you. As you and your colleagues consider the road ahead for National Highway Traffic Safety Administration, it is important to remember 3 key points. The administrator, who we are all delighted that David Strickland is now the administrator of NHTSA, as he pointed out in the Department of Transportation highlighted today, and actually I have a chart that's displayed here, that motor vehicle crash fatalities and injuries are at historic lows. It's a very, very important because that's the mission of the organization. Secondly, autos have never been safer, and they're still getting safer every day because of innovative safety technologies, including advanced electronics. And third, we need to be careful not to inhibit the innovation or the speedy identification and remedy of defects. On the first point, as the chart indicates, sometimes when you see a chart like that, it's confusing for folks, but To put it in perspective, this decline, this figure reports as a fatality per 100 million vehicle miles traveled. So there are 1.16 fatalities per 100 million miles traveled. That's down from in excess of 2. Put that in terms of human lives, and again, we all know that this is far too many. That's a significant reduction from Joan Claybrook would indicate back in the 70s when it was at a high of 51,000. Now that's a decrease of 17,000. So I think that's a very important point that there is a significant and steady reduction despite increased ownership and increased vehicle miles traveled. So I think this is a goal that we share and we want to continue to work to support. As far as the safety of vehicles, by every single measure, these vehicles are dramatically safer than years ago. And in the last 15 years, we've seen a revolutionary expansion of advanced vehicle safety technologies, including increased number of electronic components and features. Mr. Braley mentioned being able to take apart a carburetor and engine in the basement. It is indeed impossible to do that today. But a lot of the technologies that we see to meet fuel economy requirements, to meet emission controls, to provide safety are because of these advanced electronics. Also, Ms. Claybrook said that voluntary standards don't work, but in fact, many of the incredible safety innovations were voluntary and were brought about before the agency ever considered regulating it. Electronic stability control. Electronic stability control saves anywhere from 5,000 to 9,000 lives annually. Lane departure warning, over 2,700 lives. Safety belt reminders and safety belt interlock, again significant. Side airbags, forward collision warning, emergency brake assist, adaptive headlights, blind spot information system. All of these are innovations that the industry introduced ahead of regulation. Secondly, it's really important to recognize that electronic systems are often far more reliable over time than mechanical systems. I used to represent the electronics industry, and I would tell you that the advancements in solid-state technology provides increased performance. It enables vehicles to not only sense, diagnose, and also to have fail-safe modes that are not possible with traditional, historic, mechanical systems. So this is a very significant technology which is helping us to meet our goals of sustainable mobility. And third, as I indicated, I think we really have to be careful not to inhibit this cycle of innovation because this industry innovates more rapidly and gets into the marketplace technologies for consumers. And so we need to maintain a policy framework that embraces technology-based solutions ahead of regulation. And I don't think the public would be well served if automakers were forced to wait for the government to catch up with industry's innovation. And it's also important, we've talked a lot about recalls, but the vast majority of recalls are voluntary. And I have a chart here talking about detecting and correcting defects sooner. In fact, the number of recalls are up. Some may say, well, isn't that a sign of problems? In fact, that's a good point because the number of vehicles affected are coming down, so automakers are using the recall system based on data it receives not only from the consumer directly but also from the agencies to initiate these actions to identify the defects and get them remedied and get the vehicles back into the marketplace. And then just in closing, I want to make a couple points about some suggestions for this committee. And I appreciate, I know how this chairman works and I know how this committee works, and you want to build a consensus on a bipartisan basis to address significant concerns. We would respectfully submit that Congress really does need to ensure that NHTSA has the resources to do its job, and we would support this committee in its efforts. We've long advocated additional resources to fund the National Automobile Sampling System, the NAS system, which we believe is underfunded. We also support a number of other legislative elements that we hope would be included in this reauthorization, such as state inducements. In other words, working to encourage states to adopt primary enforcement safety belt laws. I know that Chairman Oberstar is looking at this in his reauthorization. Our industry spent hundreds of millions of dollars in campaign to try to pass primary seat belt enforcement laws across the country, and we've made real progress. We had 3 states this year alone. We also believe there should be a first offense with an ignition interlock requirements for impaired driving, drunk driving. The statistic that's not reported up there, the 33,000 deaths, unfortunately, 30% of those or more are the result of less than 1%, 0.5% of the drivers and those that are impaired and drunk driving. We have to get those people off the road. And then lastly, the graduated license laws for teens based on best practices, the Stand Up Act, we support that. And then there are other things that can really work to fund, support high visibility enforcement efforts such as Click It or Ticket and other limit under arrest or over the limit under arrest provisions. And again, there's an opportunity to support a driver alcohol interlocked device research program called Roads Safe Act, which puts money to try to develop research to prevent drunk drivers getting access to vehicles or starting vehicles. So we appreciate very much your work. I understand how challenging it is, and we look forward to working with you to help develop common sense solutions to some of these challenges.
The Chair thanks all the witnesses, and the Chair thanks Mr. McCurdy for your statement. The Chair recognizes himself for 5 minutes for questioning. Mr. McCurdy, there's been a lot of testimony at this hearing and in past hearings, and some of it is centered on the black box as a technological solution, or not necessarily a recording device that would help in gathering the data and also determining the causes for accidents. What is the industry's response to this phenomenon of the black box?
We believe the information from event data recorders is important for NHTSA to do its job. They do have a rule that has standardized or recommended standards for the type of data that would be acquired. I think the industry is moving rapidly towards deployment of that system. Over 60% of all vehicles today, modern vehicles, have that capability. The only caution I would give, and again, having come from the intelligence and defense world, when we talk about black boxes, or we come from the world of aerospace, where some people think that in an aircraft there's this black box that they recover after an accident. Actually, these data systems are embedded throughout vehicles, and so it's not just one solitary device. But it's important that there are commercially available tools to access that. So I think the agency's going to be addressing this, and we look forward to working with them. I think this is something that can be addressed.
Yeah. Ms. Claybrook, you indicated that you think that that NHTSA's current budget is inadequate, and that that the President's budget for this year, for next year rather, is inadequate. What do you think, as a former administrator, in today's dollars, how much do you think NHTSA's budget should be, and what do you think it should be the categories that we should look at increasing both personnel and other resources for NHTSA?
Thank you, Mr. Chairman. I think that the budget should be doubled. It's $132 million, which is a pittance by any measure in the federal government, and it should probably be doubled the year after that. This agency is starving to death. It can't do the research it should. It can't collect the data that it should. It doesn't have the expertise that it should. It doesn't have the enforcement personnel that it should. And all of us suffer from that because of deaths on the highway. And I think that Mr. Strickland is going to be a good leader for this agency. I'm looking forward to see his work. And I think he needs the resources to do it. And I've already been talking to him and the Secretary a little bit about this. And I think his answer was very appropriate, that they would use very wisely the resources that the Congress decided that they would give to the agency. He didn't say we didn't want them or that they couldn't use them. He said that they would use them wisely. And I think that's as far as he's allowed to go under the President's rules. And I'm very pleased to see that he said that.
You have given us 7.
I would comment one other thing, Mr. Chairman, which is that issues have been raised today about the reduction in death and injury on the highway, which is magnificent. But I'd also point out that after the oil crisis of 1973, there was a reduction of 9,000 deaths a year because the economy was in the sink. And I think that if you look at the documents that are prepared by the agency itself, for example, here's their list that they put out today of their crash stats. You'll see that every time there's a downturn in the economy, there's less discretionary driving and there's a downturn in death and injury. But it comes right back up again. And so should anyone suggest that this is a permanent fix for the agency, it's not. I think that, you're still going to need those resources, new safety standards, and there are many others that I didn't mention today, which I will submit a list of for the record, other safety standards that the agency is woefully behind in issuing.
Mr. Chairman, may I inject one point on that? Just clarification. I think the administrator said that it actually had decreased and declined for 15 and a half straight quarters. That's more than the current recession. So I think this is a long-term trend. It's because of the regulatory efforts, and it's because of the work of the industry cooperatively with that agency, and also the work of Congress.
Well, I would say that the acting administrator, the one who went to Japan, Mr. Medford, he gave a presentation, which I'll also submit for the record, in which he said that safety technologies had, between 1960 and 2000, saved 328,551 lives. And so I do agree. I agree with Mr. McCurdy that cars are safer today. I'm disappointed that the industry often opposes some of those improvements, but they also do take initiatives on their own, which he's mentioned. And these safety features can make a huge difference. They have made a difference in the number of lives saved, and the number of deaths on the highway today would be far, far greater were not this agency doing its work. But there's much more that can be done, and we will see more deaths and injuries when the economy.
My time has expired. The chair recognizes Mr. Whitfield for 5 minutes.
Well, thank you. This has been quite an interesting hearing, and of course, anytime we talk about death on a highway, and all of us have known people who have been killed in car accidents or have had loved ones or have been disfigured, and there's no way not to be emotional about individual deaths on a highway. But, I'm walking away from this hearing feeling a little bit better, really, about things, understanding that the Toyota issue is out there. But when you have this kind of a reduction in the deaths per 100 million miles, from in the middle 70s, 3.34 fatalities per 100 million vehicle miles, down to last year 1.16 per 100 million miles. And it doesn't really make any difference what the economy is or is not. We're talking about 100 million vehicle miles. So I think that's something we really should celebrate, to see that the fact that this fatality rate is coming down. Now, when we talk about the budget of NHTSA, I think the total budget is somewhere in the neighborhood of $900 million, but a lot of that goes to state grants. And you all may be more familiar with those state grants than I am, and I know that Ms. Claybrook is right as far as vehicle safety. There's about $132 million a year for vehicle safety. But I referred earlier, for example, to this congressionally mandated study in 2005 about the causes of vehicle accidents. And it said that 95% were due to the driver, primarily driver mistakes. And that, and 2%, by the way, were related to vehicle or equipment defect, but about 40% or 50% of that related to tires. So I'm just wondering if maybe we should look at this in a different way and try to start focusing more money on educating drivers, better educational programs for drivers. And, you know, every state sets their own laws for how old you have to be and what kind of program you have to go through to drive. Should we, because of the fact that 95% of all accidents are caused primarily because of driver neglect or whatever, should we be focusing on more programs to provide better educational opportunities for drivers to make them better prepared? And I would just ask each one of you that question and see how you would respond to that.
Well, first of all, Mr. Whitfield, thank you so much for pointing this out, and I appreciate your question. First of all, I'd like to submit for the record the problems that we see with this causation study. It's quite complicated, and I don't want to take the time today, but there are a lot of deficiencies in it. But even assuming that 95% of the crashes occur because of driver error,
Is your speaker on?
I'm sorry?
Is your speaker on?
Sorry, it is on. Sorry. Sorry. Even assuming that, which I don't, that 95% of the crashes occur because of driver error, what you have to look at is what causes the death and injury. And Dr. William Haddon, who was the first NHTSA administrator, put together what he called the Haddon Matrix. And it had pre-crash, crash, and post-crash. And what you're talking about is the pre-crash issue, which is drunk driving, falling asleep, brakes don't work, whatever it may be in the pre-crash field.
Well, Ms. Claybrook, there's only about a minute left, so I'm just going to say that you disagree with what I was saying. I'm assuming that.
Well, no, not necessarily. I will submit for the record the information on that. But what you want to do is to protect the driver and the occupants, and the way you do that is making sure the car is safe, regardless of what causes the crash. And on driver education, NHTSA itself has done lots of work on this and shown that driver education really doesn't do much in terms of the long-term driving capability of most people.
What about you, Ms.?
I like driver education, but I mean, it doesn't.
What about you, Ms. Gaudio? Do you have any comments on that?
In our testimony that we submitted for the record, we took a look at the question that the committee is asking, and in the light of all the recalls that we've seen in recent weeks, are there areas that we see for improvement? And so we've made our recommendations accordingly. We are pleased, though, that the agency and Secretary LaHood have put a great focus on distracted driving. Right. That's something that's been and obviously a big problem. So we do see a value in that particular kind of focus.
Mr. McCurdy.
Thank you, excuse me. Thank you, Mr. Whitfield. In fact, in addition to driver behavior and performance, there's the driving environment, so the condition of roads, the lack of safety features there, weather, et cetera, is a factor in 2%. And then 2%, in the other instances, about 2%, it can be attributed to the vehicle. But I would tell you, since we had a reference to older vehicles, I'll provide a record, for the record, a copy of our playbook, and it's new. It has an interesting photograph of a 50th anniversary event at the National Institute of Highway Safety, the Insurance Institute, and they did a 40-mile-an-hour head-on crash of two vehicles. One was a 1959 Chevrolet Bel Air. We're not picking on Chevy. It's actually a good story here. As you know, in 1959, well, some of you probably weren't around then, but most of us who were, you know, that's a lot of metal there. A 40-mile-an-hour head-on crash with a 2009 Chevy Malibu, which is a smaller car, and the results are dramatic. The cage, the front seat, the passenger area of the 59, those passengers would have been killed. There's no doubt. I mean, they were severely injured, you know, tremendous impact, crushing of that compartment. In the new model, the cage is intact. It also has front airbags, side curtains, and the technology in the new one also has other features that improve the likelihood of survival in a head-on crash, regardless of the cause, whether it's someone swerving. The last point I'd make in this comment made about the 3-second stop. I drive a vehicle that has push button on stop. That is one of the features that many consumers are moving towards. Are we asking now? Are we saying that consumers today, it's in the manual, it's in the instruction, and all the rest, can't take 3 seconds to push a button? I know that we panic. I know there are instances, but there is a need for education. There is a need, and maybe one of the positive aspects of all this investigation, all the reporting, is that maybe consumers are having to pay attention to actually the vehicles that they're driving. What are those shifters? Where is neutral? My son-in-law drives a Camry. When this came up, when one's in the recall, I said, he's asked, what do you do? I said, you put it in neutral, okay? You don't want to turn it off at first, and those buttons are there, and that 3-second delay is there for a reason, because you don't want inadvertent shutting off the engine, because then you could lose power. That affects steering and other conditions. So I think there's a common sense approach that we need to take. Let's find out what it is. Let's work together, and I think that's what NHTSA and the industry should be discussing. So there's not one solution, but I think there is a genuine concern about it and a genuine way to try to develop some solutions.
Mr. Chairman, may I briefly respond to the comment about the push buttons?
Certainly.
I would like to note that our recommendations have to do with when the consumer is in an emergency situation, since we have been talking about sudden unintended acceleration. And I will note also that given what's happened, it's my understanding that Toyota is working on reconfiguring their push-button ignition so it can be turned off in an emergency situation with multiple quick presses in a short period of time. So that's what we're talking about.
Thank you. The chair recognizes the gentlelady from Illinois for 5 minutes.
Thank you, Mr. Chairman. I want to apologize to the witnesses for not being here for testimony, though I have looked at it. I want to also just take this moment to say what a tremendous resource we have in Joan Claybrook, who did serve as head of NHTSA, and I hope that not only our subcommittee, but that NHTSA right now will take advantage of all of the years of experience she's had, not only as an administrator, but as an advocate. I thank Ms. Gadia and also Mr. McCurdy for the work that you're doing, but I wanted to particularly just thank Joan for decades, I won't say how many, of being an advocate for consumers. In looking at the priorities that you laid out for legislative and administrative, I mean, there's a couple things that are clearly legislative. If you think that penalties need to be enhanced, I think that's legislative on our part. But what are those things that you think the committee in particular has to deal with, and that really can't be done administratively to meet the goals that you've set out, or that the problems you've identified?
Well, I would say certainly...
Do you have your mic on? Okay.
Yeah, sorry. I would say certainly in the penalty area that that's a legislative issue. Mm-hmm. And in the funding, that's a legislative issue. The President's budget is what it is, and it's totally insufficient. And so it's not this committee's responsibility, although you do authorize, of course. I think that in the area of transparency, there have been some decisions made by the agency that this committee could change. In the Early Warning Act, while there was a lot of discussion about the information being open, in fact, the way that it was written was interpreted as not being open. So I think that it would help for clarification on transparency with the early warning system, because right now it's not available to any of us.
And that would require a change or a clarification in law? Or?
I think it would be, yes, I think it would be very helpful to have a clarification of that. In terms of consumers being able to bring a lawsuit when the decision is, a case is closed in the enforcement area, we definitely need to have legislation there because of the Court of Appeals decision. Then I think it would be very helpful to have some legislative support for improving the black box. This is something that could be done administratively by the agency. I think it would be really helpful because if the black box is mandatory, if it gathers a lot of really good data, if it can be downloaded easily, all of that data can come into NHTSA's data system, and it would vastly enhance, excitingly enhance, the capacity of the agency to analyze problems, to find out what's going on the highway, because this would be rich information from crashes that occur right then on the highway. And this information is totally lacking in the agency now, and gathering it through the NAS system, which is this National Accident Sampling System, which is after-the-fact accident investigations. There was intended to be 20,000 of them a year. It's now 4,000 because of the cost. And this, I think, will never get to the 20,000. So why not take advantage of this data that's going to be collected anyway in black boxes under what I think has to be a mandate for the black box itself, and use that data for the operations of the agency as well as particular crashes.
Mr. McCurdy, you seem to be nodding at that. Did you want to comment on this?
Thank you, ma'am. Actually, I did want to comment. We asked for additional resources for NAS. We think that data needs to be collected. And this committee has oversight of NHTSA, and the data is there, but we need to make sure that the agency has the tools and resources to gather it. My only caveat on that, and I think this is something that we need to work on, is I don't believe that the wholesale release of raw and unverified data would further the objective of quickly identifying and correcting defects. And if anything, it may lead to more litigation, and I don't believe that's the answer.
Oh, well, I should say, Mr. McCurdy, I apologize.
I actually have the mic, Mr. Chairman.
Right.
You know, I don't believe it would, in fact, do that. I would hope before the gentlelady leaves, or we at least have another round, actually talk about one of the principal issues that you're the key sponsor of, which we supported, the Cameron-Gobranson Act, and the role that we actually played, because this is one of our priorities, and it shows where we can actually work together to address significant problems. And it is, those are some of the most tragic incidents that we know. And I worked with Senator Sununu and Senator Clinton at the time,
Exactly.
as well as your staff and this staff of the committee to make that happen. And the industry fully supported that. So I want to make sure that's on the record as well.
And I appreciate that. Is there any way, Mr. Chairman, that Ms. Claybrook can respond back to that? Or do you want to?
It's just privacy information. I just want to make clear that I don't think that this data should be public as to individual crashes. It would be for statistical purposes. That's all I wanted to say.
Thank you.
All right. The gentleman's time has expired. The chair recognizes the gentleman from Florida, Mr. Stearns, for...
Thank you, Mr. Chairman. Ms. Claiborne, Ms. Claybrook, let me just follow up what Ms. Schakowsky has talked about. In these boxes, isn't the box that it's on a person's car, that box would belong to that person, wouldn't it?
Yes.
So wouldn't they have the right to opt out if they wanted to? Could they flick a switch so that if they didn't want this to occur, they could do it, or do you think that should not be?
I don't think there ought to be an on-off
Okay, so you think there should be no opt-out?
I do not think there should be an opt-out.
Okay. Secondly, the information they collect is obviously speed, perhaps location. Is it going to go beyond that in terms of weight in the car or driving habits? What, in your opinion...
On the black box?
In the black box. Because it sounds like you want to expand it, and I think many people are concerned about how the federal government will handle this data. If I don't want, say I can't opt out of the box under your persuasion, then if it goes to the federal government, how is this going to be public on the internet? Should private citizens be able to go and see that about their neighbors who are driving? And I mean, there are some privacy implications, I think, that I'm concerned about.
I really appreciate you asking the question, because I certainly didn't mean to suggest that everyone's driving every crash that occurs should be publicly exposed on the internet with the name of the person and their car and all the rest of it. The black box generally collects data 20 to 5 seconds before a crash and 5 to 10.
So it doesn't come on all during the whole time?
No.
Okay.
And so it's very, very limited time frame. And what it records is whether your foot was on the accelerator, whether it was on the brake, a lot of aspects of the engine itself, the speed of the vehicle, and so on. And that data, when I'm talking about having to go to the federal government, it would be only statistical data. All privacy information would be erased. So the federal government wouldn't even have it. It would just be statistical data. It would just be that a crash occurred and what the circumstances were, so that you can then accumulate that data and say, these are the kind of crashes that are occurring, and these are the kind of remedies that we need to think about applying because of that. So I do think it needs to be mandatory. I think it should be in every vehicle. Actually, General Motors, Ford, and Chrysler readily reveal the contents of their black boxes in litigation because they think it's advantageous to them.
Well, I guess, you know, this committee would be concerned about the privacy. Let me move on. I have another question. Mr. McCurdy, welcome to the committee. It's nice to see you. Eddie Townsend and I dropped a bill on January 28, 2009, which would direct the Department of Transportation to issue regulations which would mitigate the safety hazard caused by near silent hybrid and electric cars. I was in a parking lot going into the grocery store, and I was just walking along, wasn't thinking on my BlackBerry, and this car came up that was a hybrid, and I didn't hear it, and it practically hit me. And so my question is, I think both General Motors and NHTSA have come up and proposed methods to address this, and I guess concerning the ever-increasing desire now to have these cars that are hybrids and silent and you can't hear them. Winston Churchill almost got killed when he came to the United States and got off the wrong side of the road, and certainly if these cars are silent, he might not have been alive. And so I guess concerned with the ever-increasing danger and the sort of the inconsistency of the industry response so far, do you think NHTSA needs to take further action to ensure an industry-wide solution, perhaps something like Congressman Towns and the bill we introduced, which is called the Pedestrian Safety Enhancement Act of 2009. It has 210 co-sponsors. It's H.R. 734.
I know the bill well, and it's good to see you, Mr. Stearns. Actually, we refer to this as the quiet car legislation and concern. Actually, I think we ought to recognize, I don't know if John is still here, John Perret from the National Federation of the Blind. We at the Alliance have been working closely with NFB. Our member companies have been conducting acoustic testing. There are some challenges. You know, it's ironic, unintended consequences, but we've been pushed for years by some to say we got to reduce noise. We've been pushed by others to say we got to eliminate the internal combustion.
No one's ever happy.
You know, so we're moving, rapidly to hybrid and electric technology, and they are quiet, if not silent. I can't resist the point, though, when you say that you're walking with your BlackBerry and don't hear it. It's a little bit of distracted walking.
No,
and,
it's my fault.
We're mixing issues here, but
no,
we'll
I
talk
understand.
about distracted driving, too. But the important
But I am a pedestrian, and I have the right of way with the hybrid.
I spoke to the NFB convention
did you?
earlier in the year when they were in Detroit. Quite an event. I think they will tell you that we've reached out to them. We've worked closely with them. What we're trying to do is understand the challenges here to really understand what the acoustic.
Is there a timeline?
Signature.
Can you give me a timeline?
I think we can. Well, we've been doing the research now. I think there's questions of length of implementation, but I think we're not far from finding a
year, 2 years.
And depends on front end and back. I think we're actually making real progress, and again, we want NHTSA to engage with us as well. So I think there's an opportunity for a real stakeholder conversation here, and it's not confrontational at all. I think this is a question of it's really a question of really understanding the problem and bringing to bear the right science and engineering. But I think there will be a solution, and I think it can be.
And you think NHTSA should have a industry-wide solution? Yes or no?
It should be industry-wide. I think it's actually going to be global.
Okay.
I'm involved internationally, and I think Japan
Thank you, Mr. Chairman.
actively engaged, and others will as well.
Recognizes Mr. Braley for 5 minutes.
Thank you, Mr. Chairman. Mr. Stearns, there's a great episode on the TV show The Office where one of the characters engages in a low-speed chase with the Prius and sneaks up on one of the other characters, which demonstrates the importance of this legislation. Mr. McCurdy, voluntary can be a relative thing. And you talked earlier about some of the voluntary changes the industry had made to respond to safety concerns, but a lot of those changes that were made were also things that the industry initially resisted. And one of the great things about the country we live in is we have a system that allows people from all different walks of life to work together both in a public setting like through NHTSA and through our private enforcement methods to try to hold people accountable and work together to improve the technology in automobiles. You mentioned that you had concerns about the use of electronic data recorder information and suggested it could lead to more litigation. I would challenge that statement because I believe if you had a system with standards for accessing and downloading that information and a clear understanding of what it represented, you could actually reduce litigation. Because right now, much of the expense in a lot of these crashworthiness cases is people trying to understand how an accident occurred, how the occupant compartment was compromised and potentially contributed to the fatality or the severity of the crash. So one of the things that I'm interested in hearing from you is we've been talking about the standards for electronic data recorders, and there's already been some proposals, both by the Institute for Electrical Engineers and also proposed regulations that NHTSA is considering. And it's been my impression that some members of your alliance have been objecting to the enactment of those regulations. Are you able to make a statement here at the hearing today on behalf of the alliance that it supports the enactment of standardized regulations by NHTSA that govern the use of electronic data recorder information?
I believe we're moving in that direction. I'll put it that way. I think the industry, there's well over 64%, I think is the most recent number, maybe it was 2005 models that have EDRs. We may have been confused on all the information. I think some of the early warning information, I think, is where we have some concerns. The type of information in the EDR is probably less of a concern. But again, I think there can be movement on this. And again, I think the stakeholders and working with NHTSA have an opportunity. My hesitation was because of my experience in the electronic field is that, again, some people have a very simplistic idea of what that is. So it's not quite as simple as just saying everyone's going to have a quote, a black box. But I think we're moving in that direction.
Well, and Ms. Gotti, I want to talk to you about that because in your written statement you said the EDR information must also be standardized and expanded. And Mr. Stearns began his question by asking Ms. Claybrook about the ownership of that data and assumed that it belonged to the owner of the vehicle. And yet during the early years of EDR data availability, the manufacturers frequently took the position that was proprietary information that belonged to them, not the person who paid for the automobile. So how do we move forward from this point to try to come up with a system that makes easily available and downloadable information that achieves the privacy concerns we're worried about, but provides us with better data that helps us solve the underlying problems that leads to occupant injury?
As we noted in a written testimony that the NHTSA regulation is going to require EDRs to collect, the cars that do have EDRs, to collect certain standardized amounts of data for 2013 model year cars. We'd like to see that happen sooner. We think there's a safety utility to the information that they collect. But there are some privacy concerns about ownership of the data, as you mentioned, Representative Braley. And in the past, Consumers Union has submitted comments to NHTSA as they were considering the regulation that the final rule that they put forward in 2006. And I would be happy to share that with your office.
Please do. That would be much appreciated. Okay. And Ms. Claybrook, I want to finish with you. One of the things that we know from the medical field is a process called differential diagnosis. And that's when a physician is presented with a sick patient. They come up with a hierarchy of the possible causes of their illness, beginning with the most likely and descending to the least likely. And then the physician goes through a process of testing and evaluation to try to rule out what could be causing the illness to be able to reach a final diagnosis and a plan of treatment. And one of the concerns I have with the response we've seen to some of the problems with the Toyota recall is that the differential diagnosis that Toyota engaged in was limited, it appeared to many of us, to a mechanical failure. And they have now participated in massive recalls to address sticky accelerator pedals and problems with floor mats. And yet we still see reports of sudden and unanticipated acceleration in vehicles where those retrofits have been made. So can you comment, based on your experience as a former NHTSA administrator and as somebody involved in a long period of public safety advocacy, on what you think needs to be done to get to the underlying cause?
Well, Toyota is the only company, the only entity that can do that. They designed the vehicle, they created the software, they have software engineers who did it. The National Highway Traffic Safety Administration should not design the remedy. It never has, in any case ever. And it doesn't have the capacity to do the kind of evaluation that is necessary to figure out what the underlying cause is. A lot of people have said that figuring out a software glitch is almost impossible in some cases, particularly if no marker is left, that this glitch even occurred, a marker left in the computer. And so that's why a lot of people have talked about the brake override as the only possible solution, because we just don't, at least we don't know, maybe Toyota does, but we don't know what the problem is. I think it's very interesting that Toyota has said it's a floor mat recall of 5 million cars, and yet the remedy that they're putting in most of those cars is not only to remove or fix the pedal and the floor mat, but to put in a brake override system, which is an electronic fix. Why are they putting an electronic fix in if it's the floor mat or if it's the pedal? They say it's for customer good, so they'll feel safe. I think it's because it's a software problem. And if the vehicles have been fixed with the floor mat and the pedal and they still run away, then there's obviously another problem. And I think there are also vehicles that are not covered by the recall that may have these problems. They may not be identical. They may use a different software, so they're not identical problem. But there's no question in my mind that this is an electronic issue. And I think the company took the position early on that it wasn't, because that hurts their sales with consumers. Consumers don't like software glitches they can't understand, and they couldn't change. Now, if they change their mind, they're going to be subject to 18 U.S.C. 1001 lying to the government and going to jail. So they're in a very difficult position. Why would they do that now if they've taken this position in the hardcore way that they have? And I was at a Senate hearing the other day, and there were 21 people representing Toyota sitting in front of me. And I said to them, gee, you have a lot of lobbyists here. And they said, oh, no, these are all communications people. I think that they're looking at this as a communications fix as opposed to a real fix of this vehicle.
I want to thank all the witnesses for your impressive testimony and look forward to working with all of you as we move forward on these important issues. And I yield back, Mr. Chairman.
The Chair thanks the gentleman, and the Chair also thanks himself, thanks all the witnesses for your patience and for your time that you have contributed to us. Your testimony has been invaluable as we proceed down this path for reauthorizing NHTSA. And the Chair thanks you, and want you to know that the American people really, you've done a great service to the American people, the driving public today. Thank you very much. The subcommittee stands adjourned.
Thank you, Mr. Chairman.
Thank you so much.